Good afternoon and welcome. Thank you all for joining us for the Civil Jury Project's conversation with Supreme Court Justice Sonia Sotomayor. The conversation's title is, Will Juries Go the Way of Powdered Wigs? The Seventh Amendment in the Modern World. We are tremendously honored to have Justice Sotomayor with us today, and we're grateful to Steve Susman for his leadership and vision, without which this event today, and indeed the Civil Jury Project here at the law school, would not be possible. I also want to thank our colleagues Kathy Sharkey and Sama Sakharov, the faculty co-directors of the Civil Jury Project, who together with Steve as executive director have really brought this exciting project studying the history and potential future of the civil jury to life this year here at the law school. Steve will introduce Justice Sotomayor in a moment. I've gone from light to dark, that's interesting. She's someone who needs no introduction but tends to get one anyway. And it certainly, for purposes of our discussion here today, I think it is worth remarking that one of the things that makes Justice Sotomayor unique among her colleagues on the Supreme Court is the extent of her experience with juries. Whether as a prosecutor in the district attorney's office immediately after graduating from Yale Law School, or later in a civil commercial practice where she worked both in litigation and in other forms of dispute resolution, including arbitration. And then, of course, as a district judge in 1991, she was nominated to the federal bench, the Southern District of New York, and served there as a trial judge until 1998, when she joined the Second Circuit, and then, of course, in 2009, was nominated by President Obama, confirmed by the Senate, and appointed to the Supreme Court of the United States. And she today, of all of her colleagues on the court, has by far the most experience at the trial court level as advocate and as judge. So there is no one better situated than Justice Sotomayor to join us for today's conversation. And I will turn proceedings over to Steve Susman, who is the perfect interlocutor for this conversation. Steve is one of, if not literally the leading litigators in the country today, a very prominent trial lawyer who knows the jury deeply, having appeared in front of hundreds of them. And those people who know Steve, having appeared on the other side of the V from him, know how formidable an experience that can be. But we're very grateful to have Steve as part of our team. So without further ado, Steve Susman and Justice Sotomayor. Thank you.
Justice Sotomayor had 20 years of experience with juries before she became an appellate judge. But she got hooked earlier. At age 10, watching Perry Mason on TV.
I did.
She decided she wanted to be a lawyer, a trial eventually, and a judge eventually, that early. So for 20 years, both as an advocate and then as a trial judge, she has experienced juries both in criminal and civil cases. She is the only member of the Supreme Court who has presided over a civil jury trial and conducted one as a trial lawyer. And she said, based on her personal experience, that to the extent that judges and juries react differently to facts, it is because their life experiences are different. And that, in fact, gross disparities in result do not frequently occur. She also, last year, in a trademark infringement case, wrote a unanimous opinion from the court which said that juries can be trusted in one of the most complicated civil cases imaginable to handle a complicated issue of tacking periods of similarity of the trademarks. One of the objections to leaving the issue up to juries was that it's unpredictable. Juries are going to be unpredictable. And she convinced her colleagues to join a unanimous opinion that said that the fact that juries and judges will reach or may reach different conclusions has never stopped the court from employing juries in tort, contract, or criminal cases, and that decision-making requires judgment calls, whether made by juries or judges, that necessarily involve some degree of uncertainty. So the Civil Jury Project, which was started here at NYU last fall, we kind of knew immediately who we had to have as our first guest. We had a conference on September 11th, and the purpose of this project, it's a 4-year project, is to ask the questions, are jury trials vanishing? If so, is that a bad thing? And if it's a bad thing, what, if anything, can be done about it? That's basically the questions we are posing as researchers and academics and trying to get an answer to. And we have already over 100 judges, both state and federal trial judges, who have agreed to be advisors to the project. But no one who's in the position you are, which is the highest judge in the country, who is familiar with juries. So let me begin, Justice Sotomayor, by asking you about your experience with juries, both as a lawyer and a trial judge. Did you like it? What do you think of them? Do you trust them?
I loved trying cases before a jury. And as I got better at it, my win record increased. So sure, I liked it a lot. When I became a judge, I started evaluating the process and the outcomes by how I would have come out. Would I have reached the decision the jury reached? And there was only, well, one case, 2 trials, where I would have reached a different conclusion than the jury, but one in which I knew why the jury reached its decision. Because the very first time I heard the defendant testify, I went back to the lunchroom and said to my colleagues, "That's the best con artist I've ever heard." And I actually had a very deep feeling that this guy looked and sounded credible. Now, the process that I went to disbelieve him is a process that jurors don't know because they're not judges. And so I wasn't surprised that they came out at their verdict. And is that a bad thing? I didn't think so. Ultimately, after 2 hung juries, they took the case away from me. And I gave it to somebody else, and they offered him a lesser plea. Wasn't the end of the world. But that's my only experience. I only had one situation in which the jury was unhappy with the process. And that was because there was one overbearing juror. But even in that case, I did not disagree with the outcome. It was only that I was sorry the jury had come back feeling as if it was not a positive experience. In my experience, virtually every jury that served would tell me later that they were happy after they were picked. They were happy. I would always tell my jurors, and I tell people even now, I get so many calls from friends to ask me, how do I get out of jury service? And I still get those from my family, by the way. If I tell the judge that you're my cousin, will that get me off? Very common question. And my answer is always, why? Why do you want to get off? Such a fascinating experience. And it is the one responsibility of citizenship that no one else can actually do. And by that I mean, everybody pays taxes, whether you're a citizen or not. People serve in the military, whether they're citizens or not. Permanent residents can serve in the military. And military service is not compulsory, at least at the moment. But the only other thing that you can do is vote as a citizen. But this is the one activity where you're asked to serve and to actually come to a decision on the behalf of the society that you represent. And I think that that is a very, very important thing to remind people of.
One of the state court judges in the District of Columbia, I've been going around the country talking to some trial judges about jury trials, pointed out to me something I had never thought about, is that for many people, serving on a jury and going to lunch with the jurors and sitting in the jury room with them at breaks and then deliberating with them is the one time that they have in their lives to work collaboratively with people who are totally different.
Absolutely.
Both racially, religiously, totally different demographics, and they work together to produce a product that they are all proud of.
I have to tell you, I mean, you talk to jurors, many of them become friends. Maybe not the entire group of 12 or 6 or whatever it is in a civil case, but they will always make a couple of friends that they then keep for life. There is something about that process that is both engaging and self-fulfilling. To be a responsible person, to come to a decision after you've looked at all sides of an issue. We often don't make decisions that way. And this is a way of forcing people to think about how useful that collaborative effort can be.
Let me ask you this question. If you were a lawyer practicing law, and you were sued for malpractice, not that you would ever be sued for malpractice, but you were threatened with a malpractice suit, would you want to put your hands, knowing that jurors don't feel that necessarily, the average
Good
citizen,
about lawyers.
good about lawyers, would you feel comfortable putting your hands in the fate of a jury?
In a heartbeat. I have found my juries reach the same conclusion I would have reached in technically very difficult cases. You should ask me why I think when they don't, why it happens. And generally, the lawyers in the room are going to hate me, but it's the lawyers. You know, when I was a practitioner on the district court, the patent bar was having a very extensive conversation about whether or not they should hire trial attorneys who had no patent background to try their cases, or whether they should let the patent lawyers in the firm do it. And there were some firms that absolutely refused to hire the trial attorneys. There were other firms who did. And in a couple of cases, I had one of each. And I will tell you, in my experience, it's always better to have a trial attorney. Now, that doesn't mean
Thank
you
you.
can't. No.
Well,
That doesn't mean you can't teach a patent lawyer how to be a trial attorney. You can, but that's not where they spend their time learning. They learn the technical aspects of the case and forget that the art of litigation is just that. It's an art. It's a skill you develop.
this is one part of my questions I was going to ask you, but since you brought it up, my firm, I have 100 lawyers. We're commercial litigators. 50% of our practice today is patent infringement litigation. We do not have a single patent lawyer at the law firm because the trend has gone towards trying patent cases in a very compressed period of time, 4 or 5 days, and how you communicate facts to a jury. And lawyers on both sides, win, lose, on either side of the B in these cases, think that juries get it right. It's amazing.
Every single new U.S. attorney who used to come to me, both when I was a district court judge or on the Court of Appeals, to ask me how I thought they could improve the office, my very first answer was, go take your assistant U.S. attorneys and take them to an acting class. Show them how to be persuasive, because there is an art to persuasion. There's an art in how to explain things clearly to people, in language that they can comprehend, how to take very complex ideas and simplify them, not just for a jury, but for a judge. There's countless questions or horror stories about judges dealing with very complex patent cases that they they find that they're very uncomfortable with? Well, they're pretty intelligent people. And if they're uncomfortable with it, why should they be any different than a common juror in finding some concepts hard? That's where the good lawyer comes in. How do you simplify it?
All right, let me change the subject slightly to this issue of the declining or vanishing jury trial. I have a chart, which I'm not sure, it's back there. I don't know if you could see it, but
I've seen the hard copy.
Here's
Yeah.
here's a hard copy. The top line, it's not colored on yours, but the top line represents the decline in civil jury trials, which in 1990 there were 4,765 civil jury trials in this country. Last year there were 1,882 civil jury trials. Now, to put things in perspective, Justice Sotomayor, there were 678 active federal judges, trial judges last year, and a number of senior judges who were trying jury cases. Well, that means that our trial judges are on the average trying about 2 jury cases a year.
You know, I've spoken publicly that if and when I retire from the Supreme Court, I'm not going to sit by designation on Court of Appeals. I want to be a district court judge. You're trying to talk me out of it now, aren't you?
No,
I have something to worry about.
no.
So do we.
The interesting thing in going around seeing judges is that some trial judges are try a lot of cases. There's a big variation because the average is not what some judges are on the bench, their courtrooms are open all the time. Other judges, the courtrooms are dark all the time. So there are things that I have learned that judges can do, just like trial lawyers can do, to get business. And teaching some of them, because almost all of them want to try cases. They say they want to try cases. But there are things that I think they can do, and I'm going to address those. What concerns me about this chart is look at the trend. The bottom line is bench trials. It has gone down almost parallel with jury trials, and even a greater number. I mean, there's less than 1,000 bench trials in 2015. Maybe the problem, this is my question to you, maybe this problem is not juries, it's all trials are vanishing. Do you know why that? Why is it that, I mean, people say, well, juries don't understand. Jury trials are too expensive. That doesn't explain what's happening to bench trials. Why has everyone decided in this country it's better to go to, I say, private dispute resolution, arbitration, rather than, it's like public and private schools. I mean, you can be all for private schools and still there's a place for public schools.
I don't know that there's one reason that can explain every individual decision not to go to trial. I explained, and we were talking outside earlier, that I represented many foreign clients, and they were shocked by the civil discovery mechanism of our judicial system. And whenever we started to talk about going to trial, either on the defense side or on a plaintiff's side, they wanted a way out. And so we encouraged them to do arbitrations. First, because the types of arbitrations then, and I think that's changing and arbitrators are going to have to worry about this, then the kind of industry-run arbitrations that existed didn't have the type of extensive civil discovery. But two, arbitrations are essentially confidential. They're not public, and that's always very, very inviting to people who are not accustomed to our system of justice. That, I think, can account for why people go to places like mediation and arbitration. And as I said, way back when, and I think that's changing now, and I don't think it's going to do well for arbitration either as an alternative. Arbitration had limited discovery. Today, many arbitration associations are carrying on discovery as if it were a courtroom.
That's because you're going to have you're going to have plenty of opportunities to be a trial judge because the trial judges now want to be arbitrators.
Arbitrators, exactly.
I mean, and they are
But
taking into arbitration.
But you can pick your
Yes, of
arbitrator.
course.
And that is also an advantage for people if you want to pick someone with knowledge, if you're in an industry-run area and you have an industry-run problem, and I'm not talking about employment practices, that's a totally different discussion, an area to think about, because consumer laws have a whole lot of issues involved in them that don't make it nearly as fair as those cases involving industry problems. Now, I know why, but I'm never quite sure why in the patent field they didn't create more industry-run arbitration mechanisms, but they haven't, so.
Well, I think the problem in patents is you don't have contracts.
Right.
Pre-existing dispute contracts specifying how disputes will be resolved. It's a stranger that infringes your patent, not someone you have a contract with. So that's probably.
You also have today, almost every court system has a mediation settlement process. Even appellate courts have them. So a certain number of cases go away, or trial cases go away because of the heavy settlement pressure that's put on parties, not just by the parties themselves, but by the court as well. And that has a certain amount of deterrence from going forward.
Let me ask you this question. Because I worry with this kind of trend line happening in trials in this country. If we go to answer the question, our project tries to answer why, that's going to take a lot longer than 4 years. And the trials may be extinct before we know. No, they may be gone before we do anything. So the question for you is, if a law student came to you or a high school student and said, Justice Sotomayor, I understand that the United States is the only democracy in the world, the only country in the world that resolves civil disputes by juries. There are some places that use juries for criminal disputes, but civil, only America. Why, so big deal, why isn't it the powdered wig? I mean, why should we worry about the loss of the jury trial in this country? How would you answer that student?
I would go tell them to read about the Seventh Amendment and read about what motivated our founding fathers to think that it was an important protection of a sense of liberty. And their main reason was, remember that the crown controlled justice in their time. The crown had judges, but those judges, because of the nature and circumstances of that system, the judges hewed pretty closely to the desires of the king. You didn't keep your job if you didn't. And I think our founding fathers understand that no matter how you appoint your judges, whether they are elected or appointed, politics will always play a role in the appointment of judges. Sometimes in a big way, with a capital P, as one of my dear judge friends once said, who knows a senator? Or in a small p, that you're involved in community affairs. But I think that they understood, and I think we should understand, that the jury is the sort of front line of protecting the society and its liberties. And I think that's terribly important for us to continue and to uphold.
It's so interesting, that answer, because defenders of the jury, like me, for example, will go around, as we began talking about, and say that, well, juries reach the same decision as judges. In very few cases do you see a difference. I finished an article yesterday that Professor Charles Wolfram wrote in 1972 on the history of the Seventh Amendment that said the people who were responsible for insisting that the Seventh Amendment be part of the Bill of Rights, and by the way, he attributes the whole existence of the Bill of Rights to the concern with jury trials, and that it wasn't in the Constitution. They didn't put it in the original Constitution. It was promised as a quid pro quo for ratification that we will have a Bill of Rights that guarantees civil jury trials. That those people wanted jury trials not because they would get the same result as a judge, but because they would get a different result than the judge. And they wanted it in spite of the fact that jury trials would be longer, more expensive, maybe less predictable. So I had forgotten that. I was really never focused on that as being the reason for, if we just went back to the reason for the Seventh Amendment, you know, that maybe that's the answer to why America.
You know, the Second Circuit has an opinion that basically says that juries should never be instructed about jury nullification, and that any instruction that would suggest it is wrong. I hewed very closely to the Second Circuit line for many, many years. As I've grown more in the system and watching it, I'm not so sure that that's right. Think about what juries did during the Civil Rights Movement. If it weren't for jury nullification, we would have many civil rights individuals who would be convicted felons or otherwise for things that today we think are protected by the First Amendment. There is a place, I think, for jury nullification, finding the balance of that and the role that a judge should or should not play in advising juries about that is, I think, a different thing. But I think that you're right. Our forefathers did not believe that juries necessarily always got it right. But it was, I think, what they believed is that the jury getting wrong was better than the crown getting it wrong.
Let me talk about jury selection a little, because as you point out, that if you Google jury duty, it's all about getting out of jury duty and how you do it. I mean, there are YouTube videos after video about how you do it.
I said,
But so, and there's no question that people who go call down for jury duty come back and say, that was a total waste of time, I never want to do it again. But once they are selected, they love it. And I don't think I'm talking out of school, but 2 weeks ago, I got a tweet that Senator Claire McCaskill had been selected on a jury in Missouri, and she served in a civil jury trial. It was a trip and fall case. They had too many, they couldn't strike everyone they wanted, so both sides let her serve on the jury. It was a day-long trial. She's tweeted about this, so I'm not talking out of school, since, and she called me on the way to the airport to tell me about her experience. She's a trial lawyer. She said it was the most wonderful experience she's ever had, and the jury got it absolutely right, and that, but even there, she was telling me about, so the jury found 75% negligence, it's comparative negligence, and awarded, the plaintiff was asking for $50,000, the jury awarded $45,000. And then, but she was explaining, you know, the jury would have awarded even less than that had I not been on the jury to explain to them that the plaintiff's lawyer is going to take a big cut of whatever you award. So there's a perfect example. And in a way, that's a form of jury nullification because the jury's not instructed on that.
no,
But the 12 people were smart enough working together to figure out that very practical
now
thing.
you do know that I'm going to get a cert petition from that, in that case, arguing that the senator's information was extrajudicial and therefore that the jury verdict should be invalidated. I'm not quite sure that the tweeting stuff I really like, but okay.
In any event, well, do you believe, let me ask you this, do you believe that lawyers ought to have the right to make challenges to jurors for peremptory challenges. In other words, challenges not for cause, but challenges which aren't racially or
No.
motivated. They just don't like.
One of my colleagues has said, and I haven't checked whether it's public, so I won't attribute to which colleague it is, that he does not believe that there should be peremptory challenges at all. Having served as a judge, I certainly do think that they're needed. First of all, you do find that lots of jurors, and why we don't have as many jurors getting off jury duty is most people have a very hard time saying that they cannot be fair and impartial. There's this gut thing that tells people that if you say you're not, there's something wrong with you. And so I experienced it as a judge. I would listen to a juror come that close to telling me they were biased in one way or another, but when they were asked the direct question, can you be fair and impartial, they would say yes. I think that in fairness to the process, you do need to give lawyers some peremptory challenges to be able to take those people off the jury. You couldn't do it as a judge unless they said they couldn't be. You could in some extreme cases, but I think that they're valuable, and I think they are necessary, given how people have an unwillingness to admit their own bias.
Did you, as a trial judge, allow the lawyers to conduct any of a voir dire?
I didn't, because I really liked the federal system, even though I was the worst abuser as a state prosecutor of anyone in voir dire. I used to conduct the longest voir dires. I think there's some judges who I tried cases in front of who will attest to this, okay? But I would always ask the lawyers to give me a list of the questions and of the issues that troubled them. And it was rare the case where the lawyers would bother to do that. I almost had to lawyer for them. And in a tort case, simple question, has anybody, if it's, the injury is a back injury, has anybody ever been treated for back injury? I think you should want to know that. Whether it's good for you or bad, you should at least know it. No lawyer would ever ask me to ask that question on either side of the case. And I got very rare questions from defense attorneys. It always, always surprised me in the federal system.
Interesting.
Now, I don't know if that's because many of my colleagues would never ask the questions, but I frankly was not that way. And when I asked, I meant it. I want to know what it is that interests you. And I'm happy to, and would, when the questions were asked or given to me, I would formulate the questions in a way to get the answer they were seeking.
Let me shift focus a little to the trial itself. Since 2005, the American Bar Association and various state groups have come up with all kinds of suggested innovations. Basically, if I had to summarize them, it's to give jurors the same tools that a judge has in a bench trial as jurors, like the ability to ask questions, getting instructions on what the law is at the beginning of the case rather than at the end of the case, the ability to discuss the evidence before they go into the jury room and finally deliberate if they're all together, which a judge would most certainly in a bench trial do with their law clerk, go back and discuss what was just going on in the courtroom. And so these various innovations that have been suggested to improve the trial. One I heard recently was from a Second Circuit judge here. When we went around and met with the Second Circuit judges, he came to our judges' luncheon, and he suggested that the lawyers should make the opening, asked the lawyers to make opening statements in front of the entire jury before the panel, the 50 jurors who would come in the courtroom. The lawyers made their opening statements before voir dire, not after. And he said that engaged the jurors. They became interested in the case, and even if they weren't selected, they went home thinking, I wished this was going to be a really interesting case. I'm sorry I didn't get selected. So you hear about these things. Have you thought, what do you think of some of these ideas? Are they worth trying?
Some of them I tried. I would let my jurors take notes. But you also have to give warnings because, and I give warnings like this to student lawyers, which is if you're going to spend your time taking notes, you're not going to spend your time looking at what's happening. And what happens is just as important as what's said. How things are said, how people are responding to statements, et cetera, is part of the evidence before them because it's what happened in the open courtroom. I found over time that with that type of instruction, none of my jurors became stenographers, but I would see them occasionally writing something down. But you do need, I thought it was a very useful experiment to try. I let a few of my juries ask questions, and I've decided not to continue with that experiment because many of the questions were questions that couldn't be answered. And explaining to the jury why not created its own set of problems and difficulties. So you would get the kinds of questions. Does
What
the
were they
defendant
asking,
have?
orally, or did they write
No,
it?
they wrote them down. But my own sense was if I said no to a question, I should explain why. And if you have a question like, does this defendant have a criminal history? How do you explain, don't pay attention to that, you say it, but I think it then opens the minds of the other jurors about, well, that means that he really doesn't have one or does have one. And I think jurors are left to speculate about that to themselves. But once you answer the question, it becomes difficult to be truthful. So at the end, I stopped the asking of the questions. Some of the other things you suggested, like I find it fascinating to do your opening before the voir dire. I do think that having some preliminary instructions, because I did that, was awfully important for juries.
Like
and
the one that you just gave, I've never heard in trial. Would be wonderful if the judges said, you can take notes, but it's very important that you watch the witness as well as listen. Because, and that kind of instruction coming at the first would, I think, be so helpful to jurors.
Well, but I think that if you're going to make recommendations of that type, I would, in your report, recommend that you think of the pros and cons and some of the suggestions of how judges could implement these things in ways that would answer some of the difficulties that people are raising.
How about instructing jurors? One suggestion is that we should instruct them on how to deliberate, that people go back there and they have no idea of, like 12 Angry Men. They go back there and they have no idea how to begin or how to select a foreman or whether to take a vote when they first get back in the jury room, that they should be given some, with all the social scientists that we have working on the justice system, that they could write some instruction that would tell people, well, go back there, let everyone talk, don't take any votes during the first few hours or something like that. What would you think about something like that?
I would have a hard time implementing that or finding a way to implement it that would make sense. I think that part of the jurors' process in coming to decisions on something as preliminary as picking a chairperson or a foreperson, that helps the group coalesce and figure out its own way of dealing with things. And I guess, depending on what you showed me, I might consider it, but I see a whole host of problems with it, and including that the idea of an initial vote is what almost every jury I've heard of does. They have to have a sense of where the group is before they can even begin talking about what the issues are. Now, I know that some people might worry if it's unanimously one way or another that jurors will stop. It was very rare in my experience that juries came back in less than about an hour, hour and a half, even when they had voted, one way or the other initially. They felt compelled to make sure they were right. At least that was what was explained to me by most jurors.
Professor Miller of this law school has suggested that the Supreme Court's trilogy in the 80s of cases on summary judgment marked the death knell of jury trials, and that other professors at Yale have said that the civil rules, which require so much pretrial discovery, there's no need for a trial because you find out all the facts before you go into the courtroom. Still others claim that what judges ought to be after is being efficient in disposing of cases. That's the way they should be ranked, not how much time they sit on the bench, but how many cases they can get off their docket. And then I think another explanation I've heard going around the country is that, listen, it's all trials are going, and they're all going because of the tort reform movement and the lawsuit, the idea that if you have a lawsuit, you're a loser already, that you shouldn't have to come to court, settle your disputes somewhere else. And, and I was really surprised talking to state court judges who are doing all these personal injury cases, that invariably the state court judges say, we would have given more damages than the jury in a personal injury case. And that the insurance bar is figuring this out and wanting jury trials now. So,
well, that's a good way to stimulate jury trials.
Well, what do you think? Is there anything you think?
I don't think that I have one answer. I do think it's a combination of all of those things. I do think that there is an emphasis in the judiciary on efficiency. And at least that's been my experience as being when I was a lower court judge. How many cases you have on your docket, how fast you dispose of your motions, how long or how old your cases are reported routinely to Congress. And there's a sort of public pressure to ensure your, the 90-day list? The 90-day list, which means you have 90 days to decide a motion, that your list as an individual judge be as small as possible. All of those things, I think, lead to, and all of the things that you mentioned, to the decrease in jury trials. And you're right, it's not just the expense of the jury trial, because people are not doing bench trials either, but frankly, jury trials do tend to be a little bit longer, and you have to simplify a lot more than you might. But a judge trial takes almost as much preparation.
Well, for example, one of the innovations that I omitted, and I should have begun with it because it's the biggest innovation of all for jury trials, is the judges around the country in civil cases who are setting time limit trials and using a kind of a chess clock to say, okay, each side gets 10 hours. And whenever you're on your feet, either cross-examining or examining a witness or arguing, whatever you want, you do your time however you want, but you got 10 hours of stage time, and both sides do, and that those time-limited trials, you can get better quality jurors because they don't have all these excuses. I got a job, I'm a very busy executive, so shorter trials give you better juries. And the lawyers are saying, who are in them, that, you know what, I resisted the idea, but I liked it. It produced a better product. It forced me to go figure out what's important and only put that on. So how about did you ever limit the lawyers on how much time they could have? And would you think that would be an acceptable innovation in the civil area?
It's like everything else. How much experience does the judge have in setting the limits? Because some limits are very reasonable, but others, the nature of the case is such that it's more complex or sometimes simpler than originally anticipated. And so if you have an inflexibility about this process, you're going to get a lot of complaints. And I think you're going to end up with a lot of injustice. think judges have to be willing, if they're going to try to experiment with that, to play a little bit by ear and work with the lawyers in explaining why some things could be shortened or not shortened, if they agree to or don't agree to it, but give them some choices about it.
Do you think it might be possible, so I'm going back to the subject of jury selection, might be possible someday to select a jury by the internet? And by that I mean, you know, you can vote on the internet, you can buy a huge home on the internet, you can do a lot on the internet, right? So why couldn't
That's
we?
a new one on me.
Why? No, well, I mean, I think the bench, if we're going to save jury trials, the bench and the bar has got to be creative about how we improve things and how we make people.
No, I don't well,
I mean, suppose you gave a person a choice. You can come down and stay at the courthouse for a day or two till you're selected and you watch the film, or you can watch informational film, fill out a questionnaire, and the lawyer's going to have to exercise their peremptory challenges on the basis of the information provided in the questionnaire. But the only time you come to the courthouse, you are going to be on a jury.
I think what that misses is the dynamic that occurs among the veneer people in the discussions that go on in the group. People will say things in the process in open court that other jurors may not have thought about but begin to consider because it's been stated openly. I think that that process is so necessary to the voir dire that I think you would lose something very valuable if you did it the way you're suggesting. And I'm not sure it's going to be horribly shorter, because if a lot of what happens with how federal judges do it, you give one standard set of questions to the veneer panel completely, then you might have some specialized questions relating to the case. You have to repeat that 35 times. I do it by tape, so the judge says it once and then the tape is played for everyone. I think you're losing all the value of what happens
Getting everyone together.
In that live moment of having the jurors speaking and hearing each other.
So what can we do to make it so that people aren't trying to avoid jury service? How can we make it more attractive to people, palatable to people?
You know, I had a pretty good way of not getting people to want to get off juries, and most of it was in preliminary instructions, in explaining to jurors the importance of the process, their individual importance in being a part of the process, in talking to them about the attempt to ensure that the trial is going to be done efficiently and not waste their time. A lot of that kind of preliminary discussion goes a long way to convincing jurors to serve. Knowing, I mean, you have a lot less people asking to get off juries when they know the trial's a week long. When it's 2 weeks long, little harder, but not impossible. When you're talking about more than 2 weeks, you're going to have a hard time no matter what you do.
What I heard, a few judges around the country are now doing the early morning special with trials. They are beginning the trial at 8 in the morning and ending it every day at 1:30 with no lunch break. There are 2 coffee breaks during the day, but there's no hour and a half lunch break, so that every juror and the judge, and theoretically the lawyers, have every afternoon off from 1:30 on. So it's kind of a half-day service.
I don't think that's a bad idea. Most jurors that I knew didn't mind the trial process being an 8-hour day if the lawyers were actually working 8 hours. What they mind is sort of being told they're going to be there till 5 o'clock, but having half the day with the lawyers and the judge in another room talking. They want you to use their time efficiently. So I don't know that it's the shortened workday as such, although I'm sure that's attractive to some people. I think to lawyers, it could create a little bit of a nightmare. I think some courts already do that, where you have a half-day trial for a week rather than for 3 days. I mean, there's its own inefficiencies. I used to do it routinely on Fridays because I had my conference day on Friday afternoons. So I did exactly what you suggested. It would have an almost full trial day that way. Maybe being creative and mixing it up a little bit for the jury might be useful. Nobody likes getting home late on a Friday, so
Yeah.
do an efficient Monday through Friday, but give them off earlier. Or if there's a special holiday coming up, make sure that they leave early.
Well, you have answered all my questions.
You want to get some from the audience?
Yeah, that'd be great. We have about 5 minutes. Does
All right.
anyone in the audience wish to answer?
Betsy Seidman down there. She always has questions. Go ahead, Betsy.
I am not, as the justice knows, a lawyer, and you may also know, since my husband Nick Garifas and I had the honor of being entertained at your house. So this is a non-lawyer question, because you may have talked about this, and I may have missed it. But when you were talking about the fact that the number of jury trials have diminished, and also the number of bench trials, you seem to only then talk about arbitration. I did not hear any discussion about the settlement of trials, the role of magistrate judges in the federal system, or anything of that nature. Have they also played a large part in the diminution of jury trials, at least in the federal system?
I believe the answer is probably yes. I mean, to the extent that people are encouraged to go to mediation, I do think that's to settle their case. I think that's right.
With the judge, though, as the final arbiter, you're talking about the
Betsy, I did mention that. I mentioned that there were many reasons, including that there's more involvement by judges in civil trials in trying to settle them, so that there is some impetus to settlement when it comes from a judge. And I think we talked about arbitration and mediation. Yeah, all of those things have played a role in this diminution. I think one of the practical questions she's asking, I know in New York, maybe not in New York, but in other jurisdictions, magistrate judges are trying more cases. Was that
That's
that's
another
included
thing.
in these numbers?
Yes.
Yeah,
Well,
okay.
I think it's included in the numbers. There are magistrate judges that are doing some never try jury cases, civil cases. Others try it only with you can only try it with the party's consent. So you can't make parties go to a non-Article III judge for a trial. And the way the judges are encouraging consent, it's like selling the product. They're trying to convince the lawyers, this magistrate's a mini-me. He is going to do exactly what I would do, and he knows that if he does what I do, I'm going to uphold what he does. So you go to your client, he's going to also say, this magistrate judge can do it a year before I can do it. He can give you undivided attention without breaks. They make it attractive to both sides to go consent. Well, one of the things the project is doing is what are they using as their sales tools? I mean, how are they, I personally believe that the reason litigation is lost out to arbitration is the arbitration providers have done such a great sales job against us, trial judges and lawyers. We have let down. We are competing in dispute resolution. Well, we need to begin selling. That's one thing.
You have some jurisdictions whose criminal dockets are so large and whose criminal trial work is so extensive that they virtually, without the magistrate judges, they couldn't try a civil case for years, if that. So Betsy, that does happen in Miami, for example. I understand the numbers are so large that if you're in a civil litigant and want a trial and you don't consent to a magistrate, you and your client won't get an answer for a very, very long time.
Yes, sir.
Thank you, sir. So the trend lines on the criminal.
Could you stand up and talk real loud so we...
So you mentioned the criminal courts. The trend lines that you had on your graph and criminal cases, do they also
This does not include criminal. This is only civil.
I understand that, but do you have any data on criminal? And if so, if it goes in the same way, does it inform, perhaps inform on the decline?
Well,
don't
I
know.
can answer that for
Okay.
you. The answer is yes. I don't know necessarily if it's as steep, but it's certainly there's been in the federal system a great decline in criminal trials. I think there the reasons attributed to it, the most common is the guidelines that increased, that give everybody an automatic 2-point reduction in the sentence for substantial assistance if you plea earlier. But I also think that the higher sentences in the federal criminal system are their own inducement for sort of that whatever plea bargaining a criminal defense lawyer in the federal system can do. They try and do accomplish it because the alternative is generally substantially more than will occur after trial. So but criminal trials, and I understand why Steve stayed away from it, have their own unique reasons for the diminution.
One final question over there.
Hi, my name is Stephanie Wiley. I'm a first-year here, and I've read that there are disparities in the racial makeup of juries, and that sometimes attorneys use trained juries' challenges to affect biases. So I'm wondering, what are your thoughts on just what effect this has on jury trials, especially for people of color?
I sighed because that's such a big issue in both the state and the federal system. You have in the federal system, as in many state systems, the use of voter rolls. And as you know, minorities generally are highly underrepresented in voter rolls. Those states who care about diversity have generally expanded the use of other measures like driving rolls and things of that nature, but it really depends on how open the state and the particular jurisdiction is to diversity and its concern. We still have Batson, you're a first year, so you don't know what Batson, or do you know what Batson is? You're shaking your head no. The Supreme Court, in a case called Batson, that's how every rule gets named by the case that created it, basically says that neither a prosecutor or a defense attorney can strike a juror merely on the ground of their race. We haven't quite dealt with gender yet, although everybody, I think, or most judges tend to include gender in some way in that, falling under that umbrella. But my point is that Batson challenges, at least in criminal cases, is still alive and well. We get a lot of those cases that still come up. Does that influence how in civil cases parties make judgments about whether to go before a jury? That's something I've not given a lot of thought to, because in most civil cases, especially if you're talking about corporate disputes, it's rare that becomes an issue for anybody. The color of the jury might inform some lawyers in terms of who they select or they don't select, but I don't think that it influences their decision to hear the case before a jury. So I think that's more, it gets to be a much more sensitive issue in criminal cases than in civil ones.
Justice Sotomayor.
Although, look at the Bronx, where I grew up, and you know, it's spoken about and written about that the Bronx has a greater representation of people of color on the jury, both criminal and civil, and the awards are a little bit higher than you get out of Manhattan. But a lot of that, I think, is sort of stereotyping that one has to be cautious about. because it may well, you have to look at the individual cases to make judgments about whether race really could have been an influence in a particular case.
Well, thank you. I mean, there's such a big age difference between us that there's no way I'm going to have the opportunity to try a case before you when you go back to the district court bench.
I'm going to
And-
be the greater the loss for it. I'm sorry I didn't get a chance.
But thank you very much for coming today.
Yeah.
It was